To chair the session is my Lord, the Honorable Chief Judge of Kano State, Honorable Justice DJ Aboki. Please let's put our hands together for my Lord.
Unless this is pushed forward. Oh, no, tradition. This one is working too. Let me just keep this. This is working. Now. Because I didn't hear you say like.
For the citation of the panelists, we have it on page 34 of the e-brochure. Thank you very much. Over to you, my Lord.
In the name of Allah, the most beneficent, the most merciful, a very good morning to everyone here. Let me single out the retired JSC, Professor Tabiu, and the chair of the section of legal practice, Boma Alavi. We have the DCRs here. We have the chair of Kano. I haven't seen Ngogo yet. We have our High Court judges. Some are here with us, and other members of the bar and lower bench. You are welcome to this session, which is basically on overview of the impact of judicial attitudes on arbitration in Nigeria. Arbitration is a widely used and respected alternative to traditional litigation, offering a private, efficient, and expert-driven process for resolving disputes. Is that coming in?
I understand that the stool is shaking. I might fall off, so I'm not pushing it.
Okay, we should not use it. Arbitration is a preferred method for resolving commercial disputes in Nigeria, particularly valued for its efficiency, confidentiality, and flexibility. Judicial attitudes toward arbitration can significantly affect its efficacy and attractiveness. Positive judicial attitudes, such as respecting arbitral awards and minimizing interference, can enhance the credibility and appeal of arbitration. Conversely, negative attitudes can undermine it by causing delays and uncertainties due to excessive judicial intervention. I wouldn't want to go into what I've written out here so that I don't take much of the time, since we have about 4 panelists who are going to enlighten us today on this topic, and some will be joining us virtually, I understand. So I want to start with Mr. Agba Emuijeze. And the question I want to put to you is, we want you to examine through the cases the attitude of Nigerian courts in enforcing arbitral awards, challenges faced during enforcement, its impact, and how such challenges can be mitigated. Over to you now.
Thank you very much, my lord. Good morning, everybody. Thank you very much for this question. So we'll just take a quick look at it. What are the advantages of arbitration? It's fast, it's cost effective, it's efficient, you can choose your laws, you can choose the seats, anything you want. But what we have nowadays is that we have unenforceable awards. And who are the cause of these problems? Lawyers, we practitioners. The moment we get awards, we rush to court. The moment we get awards, we rush to court, talking about misconduct. The arbitrator has misconducted himself. We brandish Taylor Woodrow's case and say, oh, let the court set aside this award. And I think that is bad practice. So if we as practitioners take a different look at it, I'm sure we'll have more enforceable awards. If we don't go to court, then the courts will not have the opportunity to pronounce on what we have done in arbitration. I'm going to be talking about two cases here to take a look at what the courts have done with respect to arbitral awards. I'll talk about a positive effect and a negative effect. I'll start with the positive one. NNPC and Funtai Engineering reported in part 1906 of Nigeria Rotary Law Report. In this matter, what happened in this matter? There was an arbitral agreement, parties went to arbitration, there was an award. Of course, the party that the award did not favor rushed to court, asking courts to I think it's better now. The party that the award did not favor rushed to court, asking the court to set aside the award naturally. The party in whose favor the award was delivered went to court and sought enforcement. Federal High Court, Lagos. The court took a look at it and said, no, you people have submitted yourself to arbitration. You must abide by it. I dismiss the application to set aside. I uphold the application to enforce. And what did our colleagues do as lawyers? I know the money is a lot. When you tell us to come and set aside arbitration awards, the money is a lot, so we are tempted by it. We don't want to say, hey, go and abide by the award. They went on to the Court of Appeal. Court of Appeal said, no, this award must be enforced. The arbitrator did not misconduct himself. Dissatisfied again. NNPC went on to the Supreme Court. And mind you, these are taking years in between the arbitral award and the appeals that arose therefrom. So they went to the Supreme Court, and the Supreme Court said, no, you people have submitted to the jurisdiction of the arbitrator. You went through the rigors of the arbitral proceedings. Now an award has been given. You must abide by it. And that was a very positive effect, because if the Supreme Court or any of the appellate courts had said, no, you cannot, this award cannot stand, then it's a negative effect for arbitration. So that is a laudable thing that the courts have done. 3 levels of adjudication, and they upheld the award. They said that they must abide by the award that was delivered. Now let's look at the negative effect of what the courts have done on arbitral awards. So the other matter I'll be looking at is the case of UBA and Trident Engineering. That one was reported in, I think, part, let me just be sure, part 1903, Nigerian Rotary Law Report. What happened in this matter? Parties entered into an agreement, there was a dispute, and a party went to court. The second party said, no, my lord, there's an arbitral agreement, let us go to arbitration. Stay proceedings pending the time we go to arbitration. But the court said no. The court considered Section 4 and Section 5 of the previous Arbitration Act and said parties must have shown, must have taken steps to show that you want to go to arbitration, not just come to court and say, my lord, stay proceedings pending arbitration. And that matter went all the way to the Supreme Court, and the Supreme Court upheld the ruling of the trial court, saying that the party who is applying for stay of proceedings pending arbitration must show that he has taken steps. And the disadvantage with that is that if I'm a defendant and you have taken me to court and we have an arbitration agreement, and you say, I must show steps as a defendant. If I don't have a counterclaim, what am I going to do? Am I going to file a notice of arbitration? Am I going to appoint arbitrators? I'll just sit back and not take any steps. So this is a negative effect, and I'm hoping that the courts, the apex court in due course, will reverse itself on this decision, because it will have a negative effect on arbitration all through. Anything the party has, the only thing the party has to do now is to go to court and say, and file an application or file a motion or a writ instead of going to arbitration, and the court will just say, oh, UB and Trident Engineering, we cannot stay proceedings, we have to continue with the process, which will be detrimental to the arbitration community. Thank you very much.
Has come up with some innovations. We want you to tell us what those innovations are and how they have shaped the enforcement landscape in Nigeria.
Good morning, ladies and gentlemen. I want to start by standing on the existing protocols. As we know, one of the factors that shape judicial attitude in arbitration is the state of the law. So one of the issues that have been faced over time with arbitration in Nigeria has been the opaque state of the old Arbitration and Conciliation Act. So this act has a lot of opaque provisions which led to some of the problems, because as we know, the courts apply the law as it is. They can't go outside the law. So with the coming of the new act in last year in 2023, it came up with some innovations that served as a turning point for arbitration. So I'll be examining some of these innovations, and I'll be highlighting how this innovation affect enforcement of arbitral awards. So first, I will start by stay of proceedings. We've just heard from Mr. Agba that the Supreme Court in the case of UBA versus Trident said if you don't take a step, you won't be able to have shown to have said the court will not stay proceedings. But with the coming of the new act, Section 5 says the court has limited the powers of the court to not to grant stay of proceedings. Once you come and show to the court that there is a valid arbitration agreement, then the court is bound to enforce, to stay proceedings and enforce and allow parties to explore the provisions of their arbitration agreement. This is as provided in Section 5 of the Arbitration and Conciliation Act. Prior to now, the court has a discretion to look into the agreement, to look at the validity of the agreement, to say, no, you have not done this. But with the new act, if there is a valid arbitration agreement, then the court has to stay proceedings. So another innovation by the Arbitration and Mediation Act is it expunged the issue of misconduct of an arbitrator. So prior to, in the Arbitration and Conciliation Act, one of the grounds for setting aside of an award is misconduct of an arbitrator. And unfortunately, the act didn't go to define what this misconduct is. So the courts have to go to common law. We have seen this in the case of Kano State Urban Development and Funds Construction. This is a case that emanated from Kano, which the court had to go to common law to define what arbitrator misconduct is. But in the new act, the act has expunged the issue of arbitrator misconduct and error on the face of award. So the court has no longer issues about arbitrator misconduct or error on the face of the award. So another innovation is the issue of limitation law. Prior to the Arbitration and Mediation Act, there have been a lot of arguments about when the limitation will start counting in arbitration. So the famous case of CT Engineering has, in that case, the court decided that the limitation time starts counting from the time the dispute arose when the parties submit to arbitration. But with the coming of the new law under Section 34, the law provides that the limitation starts to count after the award has been rendered. So this has also go a long way to shape arbitration. Then some of the new innovations that have been provided is the introduction of the arbitral award review tribunal. Prior to now, once you're dissatisfied, you can just go immediately to court. But the Arbitration and Mediation Act has introduced another level which you can explore. Parties can, by virtue of their arbitration agreement, provide that in the event there is an award, they will provide for another tier or another avenue for another tribunal to consider the award on appeal. So they can, by virtue of their agreement, state under Section 56 that they can explore this arbitration review tribunal. So I now move to the issue of the power of the courts to award simple and compound interest, both pre and post award interest. So prior to now, the courts have to look into some cases to say that, okay, the issue has been very contentious, whether the tribunal can award a simple and compound interest. But with the coming of the Arbitration and Mediation Act, under Section 46, the tribunal has the powers to award simple and compound interest. So then the issue, I now go straight into the issue of third-party funding. Third-party funding, as we know, is a concept that has evolved over time, which has been applied even prior to the Arbitration and Mediation Act. Other jurisdictions have encompassed this principle of third-party funding, but it is now with the coming of the new Arbitration and Mediation Act, it encompassed third-party funding, which provides under Section 50 that third-party funding provisions apply to arbitrations in Nigeria. The Act provides that an arbitral tribunal shall fix the cost of arbitration in the final award, and such cost shall include cost of obtaining third-party funding. So another innovation by the Arbitration and Mediation Act is the appointment of emergency arbitrator and virtual proceedings. Prior to now, we don't have the provisions of emergency arbitrator clearly provided for in the Arbitration and Conciliation Act. But with the coming of the Arbitration and Mediation Act, it provides expressly that the parties can appoint emergency arbitrator to provide for emergency relief pending when the arbitral tribunal is composed, so which is not obtained before in the previous act. Then also the Arbitration and Mediation Act also expressly empowers the court to grant interim measures. We all know that interim measures are applicable in the courts or in litigation, but in arbitration, interim measures are also applicable, but it wasn't expressly provided for. But with the coming of the Act, this provision has been clearly provided for. Then also, the Act also provides for consolidation and concurrent hearings. So, but this is subject, because we all know that issue of arbitration is subject to party agreement. There is a lot of party autonomy. So issues of consolidation, concurrent hearings, and joinders are subject to the agreement of parties. If the parties agree, then the issue of joinder and consolidations will be applicable under Section 39. Then one of the most important innovation of the Arbitration and Mediation Act is the introduction of mediation and replacing it with conciliation. We know that the former act is even termed as the Arbitration and Conciliation Act. But with the coming of the new act, it is termed as Arbitration and Mediation Act. We all know how mediation has grown over time, which has gained acceptability, especially with the adoption of the Singapore Convention on Mediated Settlement. So this act has also incorporated the provisions of the Singapore Convention to regulate the issue of mediation under Section 87 of the Arbitration and Mediation Act. Also, another innovation brought about by the Arbitration and Mediation Act is the issue of the default arbitrator. Under the former Arbitration and Conciliation Act, if you don't state the number of arbitrators, then the Act provides that the default arbitrators are three people. But with the new Act, it provides for a sole arbitrator as the default arbitrator. Then we also have the issue of recognition of electronic communication as a means of arbitration agreement. We all know that technology has come to stay, so it affects a lot of things we do. So initially, even since before the COVID and before now, arbitration has
Of it, although it might be an expensive option, because what it means is this: parties are at liberty to put, to include in the arbitration agreement, make provisions for an arbitral, an award review tribunal. What does this mean? That means you have a second level of adjudication in arbitration. Once you have an arbitral award, you can now file what is called a notice of protest. And let me just quickly look at that. Skip my mind. You can file a notice. Don't let me delay. You can file a notice, and once you file that notice, you can appoint a new set of arbitrators. If you had a panel of 3, you are at liberty to appoint 3 new arbitrators. If you had a panel of 1, you are at liberty to appoint 1 arbitrator to review what the initial panel had done. And that award review tribunal can do 2 things: either set aside in part the award, or set aside the award in whole. And the beauty of that is, if you set aside the award, if the arbitral review tribunal sets aside the award in part or in whole, the aggrieved party can apply to courts, which is a very good instance of judicial intervention in arbitration. Apply to court and say, the review tribunal has set aside a part of this award. I disagree with it. I want you to reinstate that award. And the court, upon looking at it and finding proper grounds for it, can reinstate that award in part or in whole, which is a very good intervention on the part of the court, which the new law has brought to fore. And secondly, if the arbitral review tribunal takes a look at that award and says the award is good on the face of it, there's nothing to set aside, there's nothing to change, it now narrows down what the aggrieved party can go to court to cry foul about. So what am I saying in essence? If an arbitral review tribunal has said the award is good on the face of it, you can only go to courts on 2 grounds to try and set aside that award. And those 2 grounds are stated in sections 55.3b1 and 55.3b2 of the new act. And what does it say? 2 things. First is, you go to court, the court can set aside an arbitral award that has been reviewed by an arbitral review tribunal on 2 grounds. Subject matter of the dispute is otherwise not capable of settlement by arbitration under the laws of Nigeria. And the second ground is that the award is against public policy in Nigeria. And what does that tell us? That narrows down the avenue that we practitioners can rush to court to try and set aside arbitral awards. So with this, judicial intervention, in my view, will be reduced, because if it's not against public policy, and if it's not against, if it's not a dispute that is not capable of being settled by arbitration, what is the judge going to do? The judge going to throw us out and tell us to go and abide by the arbitral award. So I think that is a very good innovation that practitioners should take advantage of. Only that it is an expensive option, because nowadays arbitration that is supposed to be inexpensive is now a very expensive option. But I think it is still a very good innovation that should be explored. Thank you very much, Minad.
Thank you for that contribution. Can I throw the same question now at Mr. Yahya Issa? Let's have your insight on this.
My Lord, like it has been said, there is misalignment on arbitration policy and the judicial practice. It has been emphasized that it is important to have judges being involved in arbitration training, and it should be incorporated in their curriculum for the NJC. But I think it is also important for us to underscore the point that it is not only about judges, it is about us as counsel and lawyers, because we find that must every arbitration award be challenged? That is one of the things. You will see that because it is us lawyers that confront the court with these challenges. So I think it is important for us to have some kind of regulation and ethics as code of ethics for us as lawyers. It's not every arbitral award that should be challenged. We have seen instances in other jurisdictions whereby even if you approach them with a challenge or with an appeal, they will decline. They will tell you that this case is not appealable or is not capable of being challenged. But in this jurisdiction, we don't have it that way. Every case is capable of being appealed. So I think something needs to be done so that we can have regulation in place that would help in terms of curbing the excesses of lawyers that are causing problem to this litigation. And also, I think it has been also said that the issue of institutional reforms, one of the basic components in arbitration is there has to be institutions that administer arbitration. Mr. Ayorinde has stated that we have the revenue arbitration accrues in the UK. They have institutions in place that administer arbitration. So I think it is also important for us to invest in infrastructure so that we can get this revenue in terms of arbitration that will accrue to us. So I will challenge us that, especially in Kano, we don't have any formidable arbitration institution. So I think it is important, apart from the multi-door, we need to have a private and independent arbitration institution that will administer arbitration. It will help to improve our revenues in Kano, and it will help to also improve the policy on arbitration. Thank you.
The intervention, to ask or call for intervention from the floor. Let me acknowledge the presence of the leader of the bar, the president of the NBA, who just came in, and also the former leader of the bar, A.B. Mahmoud SN, for joining us. All right, we have about 30 minutes now to call for interventions from the floor. And if you want to ask any particular question, you should state the panelists to which the question is directed at. But if it's just a general contribution, well, that will be fine. But we would like you to first introduce yourself and then go on to make your comment or ask your question. Yes. All right, let me start from the right side. Yes, over to you.
Thank you, my lord. My name is Toye Krukubodesen. I practice out of Port Harcourt. It's simply a contribution. See if there is some sort of competition between them and the judiciary. And I say this with all sense of seriousness. I think it's now time, if it's not being done, and if it's being done, for us to actually dig deep and ensure it's done properly, that when processes are filed in court, beginning from the registry, significant in-depth study of those processes must be undertaken by designated officials of the registry to determine if there are agreements that make reference to arbitration. And then perhaps from that process, it goes to somebody called an ADR judge, who also reviews that process before it's now assigned to a court. Because it's very odd that when you come before the Judex, first of all, we also share some of the blame, I suspect, that is litigators. The court is not informed. But the court ought to have at least reviewed the processes before drawing court's attention of counsel and parties to why you are before me when you agreed to go before another forum to have your dispute resolved. So I think, with all sense of seriousness and responsibility, that efforts must continually be made from the registry level up onto when the matter is assigned to a judge. And even at that point, that's just my short contribution, my lord. Thank you.
My name is Oladipo Tolani. I practice in Kaduna. It will appear most of us as lawyers enjoying going to court at the earliest opportunity, at the flimsiest of Federal High Court, it can be made a professional misconduct. These are things we have to consider very, very seriously. And again, it will appear the fact that scoring system have been introduced for judicial officers, for them to be elevated, the attitude now in some courts, not every court, is to wrestle jurisdiction with arbitrators. We don't need some of these things. And we need to ensure, as far as I'm concerned, that once you discover you don't have jurisdiction, don't even attempt it. And this can only happen if judges go through their files before even allow anybody to come and take ex parte applications. That's my own contribution.
Good morning, my Lord, the Chairman. Please permit me to stand on the existing protocol. Mine is a challenge to the NBA Kano and Ngogo branches. My Lord, it is common knowledge that our courts are overwhelmed with cases. Virtually all the judges are complaining. And I noticed that I think our lawyers have failed in Kano to embrace ADR. That is why our courts are overwhelmed. Kano should not be as litigious as it is now, but because I suspect, well, I believe that the lawyers prefer to go into litigation than resort to seize the opportunity to call on the lawyers to please embrace ADR so that the courts will be relieved of the burden of too many cases. 90% of these cases can be resolved through ADR. Thank you very much. Sorry, my name is Hanif Sanusi Yusuf. I'm a judge of the High Court of Kano State. Thank you.
Thank you. My name is Buma Alabi. Mine is a comment, my lord and panelists. I hear the panelists throughout bandy figures about how much the United Kingdom is making out of ADR, 2-point-something billion, and so on. I also hear the panelists who talks about infrastructure as a way of getting more ADR work into this jurisdiction. I would humbly suggest that the first thing we have to do is, as a profession, ensure that we stick with the ethics of our profession. United Kingdom is doing well out of ADR because ethically they have a reputation that stood them in good stead. It's not the buildings, it's the people, it's the members of the profession. It is how we conduct ourselves, the sorts of cases we take, the advice we give to our clients. We should be able to say to the client, you do not have a good case, please go and settle this matter. Don't even bother to go to ADR. I'm currently involved in one. They have no defense. It's an outstanding debt of well over $1 million US. You've been owing for 4 years. We've gone to tribunal, no defense, and my colleague on the other side, who clearly is the one advising his client, is in technicalities to try and stop dispute resolution. That behavior comes from us. And until we stop that, we're not going to attract the sort of work we're hoping to attract. Thank you.
Good morning, distinguished ladies and gentlemen. My name is P.C. Mini, Judge, Rivers State High Court. I want to make this contribution arising from my personal experience as a judge. I'm beginning to hear about people from the ADR community. That's quite interesting. Now, let me urge us that, especially for the lawyers who draft the contracts, we need to be explicit enough so that we don't run into troubles. I had an experience where a matter was before me, and then one of the lawyer to the defendant applied for stay of proceedings pending arbitration. There were two agreements. The first one clearly made reference to ADR, the arbitration. But there was a second agreement which made no reference whatsoever to arbitration. Now, I placed the two agreements side by side, and I took the position that the subsequent agreement novated the earlier one. The counsel to the defendant got aggrieved and appealed. Now, the thing is this. Before he made the application for stay of proceedings, he wasn't sure whether there was actually arbitration or not. Because if he was sure, at the time he filed his statement of defense, he would have made that application. But he waited for a reply to happen. And that reply made passing reference to an earlier, and then he came alive and said, oh, you have referred to this. That means there's arbitration. And I said, no. The subsequent one, having not made any reference whatsoever to the earlier agreement, novated the earlier agreement. They are on appeal. I have adjourned the matter to a time that would accommodate for the Court of Appeal to take a decision. And I told them that if the Court of Appeal decides, let's know. Let me know whether I was wrong or right. But then the point is that the arbitration community, lawyers or what should be able to make these things as explicit as possible so that we know what we're dealing with at every point in time. Thank you.
Good morning. My name is Fola Shade Ali. I'd like to share my experience as a chartered arbitrator of what exactly is going on now in the arbitration world. Earlier on, Mr. Babajide Ayorinde mentioned the issue of there's now a new trend of counsel suing arbitrators. It's definitely unacceptable. I don't know when this started, but I have been sued twice. All members of the tribunal be looked into. An arbitration clause that specifically states Lagos as an example and goes to Imo State or Abia State to file an injunction is very worrisome. And there's a need to look into this. Also, I think the issue of cost has been a deterrent to arbitration. I really need to be realistic. Most parties are not proceeding with arbitration. Even when you are appointed, halfway down the line, they decide to settle because of the cost, because it's always linked to the quantum. The AMA also provides for mediation, which is really, really a welcome development. Because at the end of the day, arbitration is supposed to be for speedy resolution of disputes. Where you have levels of appeals, the ART, the Arbitration and Review Tribunal, for me, is another layer, and then you have a right to appeal. I think this really just makes the nonsense of what arbitration is supposed to be. So really, I think there's a need to have a discussion. Where are we going? What are we trying to achieve? What is arbitration for? It's to resolve disputes speedily. So when you have all these layers of me being able to appeal, even though they say the grounds are limited, I just think it's an avenue for counsel to take advantage. And then the arbitration award is no longer final and binding. Thank you.
Good morning, my lord. Standing on the existing protocol, my name is Reginald Oguado, Port Harcourt branch. My lord, my intervention is in two ways. Now, the first one is regarding our colleagues. We have a situation where a colleague meets a client. What should be uppermost in our mind should be what is the commercial interest of the client. Now, because it is not on our mind, what we see ourselves doing is you are dishing out advice that clearly in your mind you know is wrong. Why do we do this? Because we have in the LPA immunity against professional negligence during proceedings. If that is removed, I'm sure we'll be more circumspect in dishing out advice and running to the courts. Now, taking a cue from what Abba said about the NNPC case, where after award had been given, you now go the whole hog from the High Court to the Supreme Court. Now, the Supreme Court says the award is valid. I think the court should go further to award substantial costs, because the person has been dragged through arbitration, through the High Court, through the Supreme Court. At the end of the day, you say it's just the award. What happens to the expenses? I think the courts can help us by making sure that punitive costs is awarded when these things happen. Thank you, my Lord.
Thank you, my Lord. I stand on the existing protocol. My Lord, I just want to make two suggestions. Possibly it will aid this problem we're having. One, I see that the arbitrators should see themselves as reconciliators other than passing judgment. If you reconcile two persons and they come to an equilibrium position, you will give a verdict that will not be challenged because they all consented to that position. I think more than often, the arbitrators will go and be writing judgments, passing decisions. And this is what provoked lawyers going to High Court to set aside the award based on misconduct. I think the arbitrator should maintain a middle course, try to settle them rather than writing judgments. Two, I think we need to have a panel that arbitration award will be appealed to rather than, and probably the law should now go further to say that if you have problem with the award of arbitrators, what you do, you go to appeal panel of arbitrators. And from there, it ends there. I think that will lessen unnecessary application, asking for setting aside the award made by arbitrator. Thank you, my Lord.
Thank you very much, my Lord. My name is Haruna Salah Zakaria. I'm from Kano branch. My question is directed to Babajide, the first speaker online. My question is it the jurisprudence of ADR that allows for the employment of litigation in undermining the progress of ADR in Nigeria, or the involvement of lawyers that is making ADR as technical as litigation? Thank you very much.
My Lord, my name is Yahya Muhammad Sani from Kano Multilaw Court House. My Lord, concerning the issue of participation of lawyers in promoting the ADR in Kano State, I can practically say that the Kano Multilaw Court House was in existence since 2008. Recently, 2022, we have a law at hand. We now a legal entity to operate ADR process in Kano State. And we have all the machineries. But unfortunately, if you look at what is happening in Kano Multilaw Court House, if you take the statistics of our cases, we used to receive cases in two ways. One, walk-in. That is, any person who has an issue, he can directly come to Multilaw Court House and file his action. But in that process, if you serve the process to the respondent, if eventually he has a lawyer, his lawyer will advise him not to submit to the jurisdiction of the Kano Multilaw Court House. And the Kano Multilaw Court House has no power to enforce you to appear before the Kano Multilaw Court House. This is what we are facing. If you take the statistics of our cases, out of 100, you can hardly have 5% cases filed by a lawyer. Even if in court referral cases, the case was referred from either magistrate or high court, and if the parties appear before you, the first thing the lawyer will say, he is not willing to continue with the ADR process, so he wants his case to be referred back to the to the High Court for the continuation of the litigation. In conclusion, our lawyers here in Kano are not patronizing the process of ADR at all. This is my submission. Thank you, my lord.
Good morning, my lord. My name is Muhammad Bashir Yama. Stand on existing protocol. I'm from Kano branch of the NBA. Contrary, my lord, if I may speak for lawyers in Kano, some lawyers in Kano, some of us take the advantage and employ the use of the ADR. But my lord, what we normally come through, or what we face, sometimes at the ADR panels are not, they are not encouraging. A client of ours called us and told us they were referred to ADR, Kano Multidor Courthouse. We advised the client to honor that invitation. After the deliberations, what our client informed us was not encouraging. When we tried to make effort to find out what was deliberated at the ADR, unfortunately, my lord, there was no record or substantial report that we can rely on and know what actually transpired at the ADR. In fact, there was no report or a formal report written to the court who made the initial reference to that ADR. It was a magistrate court. After everything, my lord, there was no something to show that there was an ADR between the parties, and this was the outcome. In a nutshell, what I'm saying is, I think the Kano Multidor Courthouse has to do more to make ADR attractive to lawyers in Kano. I was sometime in Lagos, and the Lagos Multidor Courthouse was a sterling example. In fact, it makes arbitration interesting to lawyers, even to non-lawyers. You see non-lawyers coming to the Lagos Multidor Courthouse to utilize their facilities. Not just Lagos Multidor Courthouse, there is also the ICANN Institute. They have their own tribunal too in the island. So there's more that needs to be done by Kano State to make lawyers find arbitration more interesting. We know that arbitration is paying. We want this money as lawyers, but we think Kano Multidor Courthouse needs to do more. Thank you.
Hold on. All right. We'll take only you, just you.
Thank you, my noble Lord. I have some comments and few questions that the panelists may consider in their concluding remarks. First is on the issue of that has been raised by my noble Lord, the Judge of Rivers High Court, on a case that is before him concerning arbitration that's on appeal. Once in an arbitration agreement, once there is separability clause, whose effect is to make each of the clauses of that agreement independent, and that agreement is valid, novation cannot take away the jurisdiction of the arbitral tribunal. So the proper thing is to refer to that case if the first agreement is valid in all its material particulars and there is severability clause, it should be referred to arbitration. That has been the international standard. And then on the issue raised in respect of the non-utilization of the multi-door courthouse, in terms of arbitration and mediation, there are two ways to invoke the jurisdictional arbitral tribunal. First is to have an arbitration clause or arbitration agreement, or alternatively to have a submission agreement. So where a walk-in person that come to a multi-door courthouse, walk in and wants to resolve his dispute by ADR, the first thing to ask him to do is to enter into a submission agreement. And then the other party will now be invited before even commencement. Once that party is sensitized as to the length, the cost, and everything, that party will be able to submit. So after endorsing submission agreement, it will be difficult for parties to resile out. So that is one way you can ensure that the facility offered by multi-door courthouse is utilized. The second way is to continue educating people, sensitizing them on the merits of arbitration as against other dispute resolution mechanisms, especially the litigation in the courts of law. Then my questions are for the panel to shed light on some of the limitations of arbitration so that it will be attractive. For instance, consent is the cornerstone of arbitration agreement. And to that extent, third parties that are not parties to arbitration agreement would usually not want to be bound by arbitration agreements. So to what extent, taking into consideration the Arbitration and Mediation Act 2023, has the new Arbitration and Mediation Act provided a buffer for utilization of the law to ensure that third parties are also binded into arbitration proceedings? The second question is on the legitimacy concerns, rule of law standard, the length of the arbitration agreement, and the cost. What can we do to ensure that those things are deepened to ensure that arbitration, though rooted as a mechanism of dispute resolution, is also given more consideration than litigation? Thank you, my noble Lord.
Thank you very much. I think we've taken enough from the floor. And I understand there is a question. If you are not going to take more than 2 minutes, I'll allow you. Just 2 minutes.
Okay. My Lord, may I stand on the existing protocol? My Lord, my name is Rulwano Umar from Kanuba. My Lord, I want to join my colleague who, my Lord, just said that the Kanuba. My Lord, the Kanuba have been participating and also receiving ADR as a method before filing action. But my Lord, the Kanu Multido must do much more than that. My Lord, I participated in the ADR in Multido. But my Lord, up to today, there was no report, no comprehensive report, and it's a referred case from the High Court. And there was no report at all. So we wasted more than 8 months without nothing to report back to the court. So my Lord, they need to do much more on doing that. My Lord, right there to that one also, I want to find out from the panelists, my question, that whether there was any method for people who are indigent, who have cases and those their cases supposed to participate in NDR, knowing the fact that the ADR is very expensive, they cannot afford it. Was there any window of pro bono, a sort of, within the ADR that people who are indigent and their cases need to be helped in deciding those matters speedily, whether they can also participate? Thank you, my Lord.
Thank you. There's a question directed at one of the panelists, Babajide Ayorinde. Let's have him respond to that question first. And of course, the one just asked, which is directed at all the panelists. Let's have his response on this, please.
So I was asked.
Thank you, Milord. I'll just answer some of the questions that I got from the gentleman sitting over there, and I'll conclude. So the gentleman there talked about third-party enforcement award. If I got him correctly, he's talking about how arbitral panels can affect third parties. Unfortunately, arbitral decisions rather cannot affect third parties because if you are not a part of the proceedings, then they cannot affect you. So you have to be a part of it and you have to consent to it before it will affect you. Then talking about costs, I know that the new act has streamlined the way arbitrators can charge. There's a scale of fees now, and I think that will make arbitration more fashionable more enduring because parties can now calculate the fees that will be payable to the arbitrators, and it will not be just according to the whims and caprices of the arbitrator. So that is a good innovation because now you can determine what will be paid to the arbitrator. Then lastly, on the issue of indigent parties, like Baba Jimmy said, arbitrators do this thing for a fee. But with the innovation, with the advent of the multi-door courthouses, I think the parties can take advantage of the multi-door courthouses, particularly in Lagos. We file matters in Lagos now, and they mandatorily refer us to the multi-door courthouse. And I can tell you that a lot of matters have been resolved at that level, free of charge, and I think that's a good innovation that parties should explore, going to the multi-door courthouses of various states and getting their disputes resolved. Even in Lagos, we have what we call the settlement week, where a lot of matters are referred there, and parties can even bring their own matters there, and they will be resolved within time and free of charge, which is very important for the indigent parties. And to close, my lord, let me just state that, drawing from what Mrs. Ali said, now that we have the award review tribunal, I think it is not out of place to suggest that the level of appeal for arbitral awards should stop. Maybe at the Federal High Court level or at the Court of Appeal level. There's no need for us to go all the way to the Supreme Court to rehash what the Federal High Court or the State High Court or the Court of Appeal has said. Look at this example, the Mercury case now, Mercury and Imokwere. This matter, the award was delivered in 2007, went up to the trial court, they finished there in 2011, Court of Appeal 2014, Supreme Court 2019. What are we doing there for that long? Look at NNPC and Funtai. The award was delivered in 2006. Supreme Court laid it to rest in 2023, about 18 years after. There's no need for, and all three courts said the same thing. There is absolutely no need for that. A major innovation that will help the arbitration community and arbitration practice is that level of appeal should stop at a certain level. It might be at the High Court level, or it might be at the Court of Appeal level. It has to stop. We do not need to burden the Supreme Court with all these appeals that will take forever to be determined. Thank you very much, everyone. Thank you, Madam.
Thank you. Well, we've heard so much from the four panelists on the topic for today. A lot have been said about what the courts needs to do on their part towards achieving the aim of this arbitration itself. We've had suggestions on how we can avoid the challenges that have been faced in the enforcement of arbitral awards. The speakers have also pointed out a lot of the innovations, so many innovations that have come with the new act, which will go a long way in helping to develop arbitration itself in Nigeria. We've also heard of the parts that the judges need to play, and most of all, what judges need is the training, understanding of how arbitration works, so that when any matter that pertains to arbitration comes before us, we know how best to handle such matters. Interestingly, and fortunately, in Nigeria, once there is an arbitration clause in an agreement, that matter cannot be heard before a court of law unless the arbitration process is conducted. This is a tried matter, and I've heard some of the speakers from the floor raise the issues on some of these cases that have been handled by the courts, despite the fact of the agreements having arbitration clause, and what probably we should do when directing such cases. But I think that what the council on the other side needs to do, if once there's an arbitration clause in an agreement, and the other party decides to bring the matter to court, I mean, the next step you take is to inform the court by whatever is it, by mode of application or even orally, and bring the attention of the judge to the fact that there is an arbitration clause in the agreement. And therefore, I think any court will readily, I mean, not take of the matter, because in that wise the court will lack jurisdiction to proceed with the matter until the arbitration process is carried out. On arbitration, on enforcement of arbitration awards, I'm really not in a position to say much on this. But I think the reason, probably, as some of you have mentioned, is that in this part of Nigeria, Kano, for example, we don't really have much cases of arbitration. And as the director of Multido Courthouse, Kano, also pointed out, there's not much patronage from the lawyers. Honestly, in the 18 years I've been on the High Court bench now, I've never had the benefit of having any case that has to do with enforcement of arbitral award before me. So let me just tell you, I don't know anything in that area. There is therefore need for us, judges, to be trained, as has been pointed out, on issues. I know some of us have undergone training mostly on mediation, other forms of ADR, and perhaps the thought is arbitration is not something that we really go into until perhaps we retire. But then, given what has been said here, and the fact that some of these disputes concerning arbitration itself comes before us, there is need for us to have proper training and understanding of the arbitration process itself. So in this wise, we would also make suggestions to the NGI to include as much as possible programs, training on arbitration for judges in Nigeria. Talking about the Multido Courthouse in Kano, about 2 people have mentioned some of the constraints or shortcomings of that place. Let me just say that this is something we'd gladly look into. And we also call on the lawyers, those of you who have come across, who have come in contact with the Multido Courthouse and have found some of these shortcomings, you can please bring it to the fore. If you have suggestion on what obtains in other courthouses around the country, you can also bring this to our suggestion, to our knowledge, and it's something that we will look up to, because as is generally known, ADR itself, it's the in thing now. Litigation is not something that should be encouraged. In fact, it should be discouraged. A lot of our courts now are having to deal with cases that we've never, in such volume that we've never had this before. And therefore, there is need for lawyers to play a role to discourage litigation when your clients come to seek your advice or professional advice, and whether it is possible for you to explore ADR by whatever form, whether it's arbitration or mediation. I think you should encourage that. And I think also you should, as much as possible, encourage your clients to submit to these ADRs, especially when such cases are referred to the Multido Courthouse from any of the courts here in Kano. I think that perhaps there is need for us to have a law in place that would make certain category of cases, of disputes, have to go through ADR compulsorily before such matters can be litigated. Because I know in some of the states in the US, they have such laws in place, and it helps seriously because, as has been pointed out, the Multido courthouses do not have the power to mandate or force any litigant to subject themselves to the process of the ADR. But if you have this law in place that says in certain category of cases, you must go through ADR first, I think that will also help reduce the volume of cases we have in our courts, and also help generally in having a society where this concept of ADR is widely embraced, not just by the members of the legal profession, but the general populace. On this point, on this note, let me thank all the panelists for their wonderful contribution. We've all learned a lot, especially myself, from some of the innovations and areas that need to be addressed to help the arbitration process work in line with what obtains with international best practices. I will want us to give a round of applause for all our panelists. Thank you very much for your contribution, and God bless. Thank you.
Thank you, Chair of the panel. Thank you, all the panelists. Indeed, as we said from the beginning, it's been quite insightful. Please let's put our hands again together for this panel. Let me welcome in the midst Honorable Justice B.M. Ugo, JCA. You're welcome, Lord. I would request that we come down for photograph. We would send you the plaque. We would not want to burden you with excess luggage. So we send to you the convenience of your home offices. Thank you very much once again. So as a step down, let me quickly say that it's one thing to hear, it's another to do. If we must achieve the overall efficiency